All right, so a conversation about the Fair Debt Collection Practices Act dovetails very nicely in with Terry's presentation on consumer debt issues. She talked in great detail about some of the defenses that are available to debtors, and I want to just talk a little bit today about the Fair Debt Collection Practices Act because sometimes that statutory regime comes into play when you are dealing with debt collectors. Now, it says here on the slide that it's an introduction to the Fair Debt Collection Practices Act, but really we're probably going to go for the next 3 or 4 hours and just cover everything in the statute. Of course, I'm just kidding, but we're just going to talk about just really sort of touch upon the very important issues and just try to give an overview and an introduction to a wide variety of things. But of course, as with any body of law that's very statutorily driven, I would just encourage you to take a look at the statutes to get a good idea of what's going on here. So what are we going to do today? We want to talk a little bit about the history and definitions of the FDCPA. We want to talk about some of the compliance requirements, some of the fairly typical violations that we might see. And we want to talk about enforcement and defenses that are implicated with the Fair Debt Collection Practices Act. And we're going to touch real briefly upon some ethical considerations because oftentimes you may be dealing with individuals who either have not had counsel or don't have counsel. And finally, we'll just talk about some best practices. So first of all, we've heard Terry talk a lot about some of the issues that were involved in representing consumer debtors and some of the findings that came to light after a result of inquiry in terms of some of the practices of some of these debt collectors. And so it should be no surprise that in the introductory section of the Fair Debt Collection Practices Act, we have a congressional finding where we talk about, where Congress talks about an abundance, I like that, abundance of evidence with respect to abusive practices that go on within the world of debt collection. And one thing, Terry, that I find interesting is that Congress makes it a point to talk about how the practices contribute to the number of personal bankruptcies, marital instability, loss of jobs, and invasions of individual privacy that go on with respect to debt collectors. I'm especially interested in Congress's concern with respect to invasions of individual privacy. I guess they wanted to keep a monopoly on that and didn't want to share invasions of personal privacy with any of the debt collectors. But in any event, so we want to talk a little bit about what Congress has done to try and protect against and or provide remedies in the event of debt collection sort of gone awry, right? So let's talk a little bit about the purposes of the Fair Debt Collection Practices Act, and really they're threefold. And I'm not going to bore you with reading the statutes, but I'm going to bore you with telling you what the statutes are. So really the threefold purpose of the Fair Debt Collection Practices Act is, number one, Congress wants to eliminate abuse of debt collection practices. Two, they want to protect legitimate debt collectors from unfair competitive advantages. And then number three, Congress really wanted to try and set up a uniform body of law, sort of a uniform a regime when dealing with debt collection practices and in order to protect consumers from state to state. So in order to do that, it's probably going to be beneficial for us to talk about the applicability of the Fair Debt Collection Practices Act. And really, the definitions here are a very important part of understanding the Fair Debt Collection Practices Act and the protections that are afforded under the FDCPA. Because without really a thorough understanding of the definitions, the rest of it's just sort of moot, frankly. So this is probably where we're going to spend most of our time, well, not most of our time with respect to today's conversation, but in terms of actually reading the language of the statute, this is probably where we'll spend most of our time. It's very important to understand these statutory definitions. So first of all, we want to focus on really four definitions within the statute. The first being a consumer. And really that's any, as we read here, any natural person obligated or allegedly obligated to pay any debt. So primarily we're talking about the individuals, the debtors that Terry has talked about, the defendants in these cases. So we've got a consumer more than likely that we're dealing with in terms of someone who may be being pursued by debt collectors. Debt we'll talk about more here in a moment, but really a debt that is subject to the Fair Debt Collection Practices Act is any consumer debt, really. I mean, that's just sort of writ large. We're talking about consumer debt here that's taken on by an individual, not by businesses, but taken on by an individual. A creditor is the person who actually lends the money, right? So who are we talking about here? Well, we're talking about, Wells Fargo, HSBC. You talked about Bank of America, I think, as one of the lenders in your example. So a creditor is really the person or entity that lends the money. And then finally, debt collectors. This is the most important, in my opinion, the most important definition under the FDCPA is debt collector. Because more than likely we're going to be dealing with a consumer, more than likely we're going to be dealing with a consumer debt, and more than likely we're going to be dealing with a consumer debt that was created because someone lent the consumer money, right? But the biggest issue is understanding whether the individual trying to collect the debt is a debt collector for purposes of the Fair Debt Collection Practices Act. So let's take a look at what we need to examine in order to determine if an individual or an entity is a debt collector for purposes of the Act. So first of all, we really want to focus on the fact that it can, in fact, apply to attorneys. Attorneys that regularly engage in the collection of debt or hold themselves out as debt collectors can be subject to the Act. So really, let's take now a look at the touchstone, right? The touchstone is an individual whose principal business is the collection of third-party debts. That's the principal definition that we want to focus on in terms of defining a debt collector, is if the individual or entity is in their regular business is the collection of debt on behalf of a third party. That's who we're talking about here. We're not talking about, as we go into the next bullet point, we're not talking about creditors. So if you have if there's a mortgage, if you every month write a check to Bank of America, or there's an electronic withdrawal because Bank of America loaned you the money to buy your house, Bank of America is not a debt collector. They are a creditor. They loaned you the money. What we're talking about is if you fall behind on your payments and Bank of America goes out and hires ABC Debt Collection Company. It says, ABC Debt Collection Company, your principal business is the collection of debts, so I want you to collect this debt on my behalf. ABC Debt Collection Company becomes the debt collector for purposes of the Fair Debt Collection Practices Act. So that's a very important consideration, is that in order for the FDCPA even to come into play, we have to have a debt collector as defined by the statute. So remember that touchstone. Is this an individual or an entity whose primary business is the collection of debt on behalf of third parties? If it is, boom, we're in FDCPA land, and now all these other violations and the enforcement and defenses that we're about to talk about come into play. So I guess we can go ahead and assume, for purposes of the rest of the conversation, that we have and that we're dealing with a statutory defined a debt collector. So again, just real briefly, what's a covered debt? Well, it does not include businesses, doesn't include debts in the operation of a business, doesn't include taxes or criminal investigations. Again, we're talking about consumer debt. Any obligation or alleged obligation of a consumer to pay money for goods or services that are primarily used for personal use, family use, or household use. Again, we probably have got that if we're dealing with a consumer debt issue in General Sessions Court. So, if we're dealing with a debt collector, as that's defined under the statute, the first thing that I would advise you to do, and one thing you want to keep in mind, is get from the consumer all the documentation they possibly have. Any letter they've received, anything that they have received in the mail from the debt collector, and take a look at it. Why do you want to look at it? Well, you want to look at it to make sure that the requirements under the FDCPA have been followed in terms of what's required under the statutory regime of a debt collector to be included in any written communication with the alleged debtor. So, again, you all can read the statute for yourself. I've got it there on the slides. But you need to watch out for the following things. In initial communications, it has to be really clear and stated expressly that it's a communication for a debt collector in the attempt to collect a debt, and that any communication that follows between the consumer and the debt collector will be used for that purpose, for the purpose of collecting debt. Every subsequent communication needs to contain the language that it's a communication from a debt collector. Additionally, within 5 days after the initial communication, a debt collector shall, right? It means they got to do it. So the debt collector has to provide to the debtor a statement of the debt owed, the name of the creditor that's owed, the right to dispute the validity of the debt within 30 days, and the statement that if the validity of the debt is disputed, that the debt collector will provide verification of the debt. And again, failure to dispute in the initial stages of that communication does not operate as a waiver by the debtor. These are just affirmative duties that the debt collector has in terms of communicating with the alleged debtor. Additionally, the name and the address of the creditor need to be included. So long as we're talking about communications, right, let's talk about communications with respect to third parties. Terry did a great job of talking about some of these block parties, some of these office parties that debt collectors have historically engaged in. If there is a debtor, say it's your next door neighbor, Terry gave a great example about how sometimes debt collectors would go out and actually go from house to house and say, hey, you know what, your neighbor, kind of a deadbeat, is not paying their debt, and you should just know that you've got a deadbeat living amongst you, right? So we want to talk about some of the prohibitions under the FDCPA in terms of the ability of a debt collector to communicate with third parties. So here we see that in terms of communicating with third parties, really the only thing that a debt collector can do is say, hey, here's who I am, I'm Brad, and I'm trying to confirm or correct the location information of a consumer, and not reveal that in any way that I'm trying to pursue a debt, right? And we cannot, as debt collector, I'm not a debt collector, but as debt collector cannot communicate with any such third-party person more than once, unless that person says, hey, I can't talk right now, call me back. Unless there's an express request to communicate again with that third party, debt collector cannot contact them again. Continuing on, you can see there are a lot of prohibitions on communications with third parties. Debt collector can't communicate by postcard. Why not? Well, we all know what a postcard is, right? Usually it says something like, wish you were here, or glad you're not here, with some beautiful picture of a beach. Probably a postcard from a debt collector is going to say, hey, this guy owes us a bunch of money. Have you seen this person? We're trying to find them to owe a bunch of money. So they can't communicate with a postcard. That's going to tip the hand that the communication is from a debt collector and that the person allegedly owes a debt. Along those lines, they can't use any type of language or any markings on the outside of an envelope that would indicate the communication is from a debt collector, or that the communication is for the purposes of collecting a debt. And then finally, and this goes, I think, probably for any type of matter, right? Once the debt collector finds out that the alleged debtor is represented by an attorney, debt collector can only then communicate with the attorney unless the attorney fails to respond within a reasonable time. And I've never run across an attorney that fails to respond within a reasonable time. Have you, Terry?
Never.
All right, fair enough. So the debt collector then needs to cease communicating with anyone other than the attorney. One thing that I thought was interesting, especially in light of Terry's conversation and description about the contracts with credit card companies, some of the language that's written on the inserts with credit cards, is that the case law is really clear that any communication that comes from a debt collector needs to be interpreted from the perspective of, quote, the least sophisticated consumer. And I think that really goes to Terry's point about the ability, or rather the inability, of a number of our citizens to engage in things like balancing their checkbook, or, as I think as you pointed out, completing job applications, or understanding the financial terms involved in any type of a credit transaction. And so really it's important to, as you analyze the documents from any consumer, to really sort of parse that language and try to identify if the language really is tailored to the understanding of the least sophisticated consumer. So we've just run through a litany of prohibited communications, right? And we've just talked a little bit about the style of communication that's required under the Fair Debt Collection Practices Act on the part of debt collectors. And so you can see that there really are many requirements with respect to communication under the Fair Debt Collection Practices Act. We ran through them very, very quickly. I just wanted to make you familiar with the fact that there are a number of communication requirements under the FDCPA. So when you do decide to represent a consumer and you acquire the documentation, the letters, communication they've received from their debt collector, again, I would just go through, take a look really closely at the language that's in those communications, go back to the statute, and just make sure that the communications have complied with the FDCPA. If they haven't, as we're going to talk about here in a moment, there's been a violation. And the significance of a violation of the FDCPA can be fairly significant for the purposes of this conversation in terms of representing indigent individuals who are being pursued by a debt collector. So you want to talk now, move a little bit from the compliance and the language side of the FDCPA to talk a little bit about violations other than those in the compliance rubric. So as you can see here, we've got this lovely picture of a maze, right? Kind of wish on a hot day like today is in Nashville, wish I was hanging out outside, maybe knocking back a cold one or something like that. But the maze here of the FDCPA, there are so many ways to violate this statute. We want to talk briefly about the ways that can be pitfalls, really, for debt collectors in terms of their communications and their tactics for collecting debt. So we're going to talk first about restricted forms of communication. We've already talked about some of them, so forgive me if we touch upon them again. But again, you cannot, or rather a debt collector cannot discuss the debt with a third party. Debt collector can really only contact third parties for purposes of securing contact information for the debtor. Debt collectors cannot call before 8 a.m. or after 9 p.m. Try to give them some sleep. Debt collectors cannot contact the consumer's place of work if the consumer has notified the debt collector not to call work. And what I find interesting here is that oral notice is sufficient. They also, again, cannot contact the consumer if they know that the consumer is represented by an attorney. And interestingly enough, I always thought this was interesting personally, but I find strange things interesting. That the debt collector cannot contact consumers if the consumer advises the debt collector in writing. Again, there's a difference there. In writing, to cease communications, just says, hey, stop talking to me, I'm refusing to pay. Communication needs to cease right there. Let's talk about some of the more, at least in my experience, where you're going to see maybe the violations are a little more prevalent. I think that there's a lot of boilerplate language that's available to debt collectors that oftentimes most of their communications are going to be compliant, especially if they've been at it for a while. Their communications are going to be compliant. They're going to meet all the statutory requirements in terms of providing notice of who they are, purpose of the communications. They're going to provide the written notice that's required within 5 days and then in 30 days. Most of the time, in my experience, I've seen the debt collectors comply with all of those situations. Really, with respect to where we're going to see, at least I've seen, violations more frequently, is when we get into the issue of abuse or harassment. So let's talk about some of the prohibitions with respect to abuse and harassment. First, there's just this general principle, right, that there's a prohibition against harassing, abusive, and/or oppressive conduct. You just can't be a jerk, I guess. Well, I guess you can be a jerk, but you can't be too much of a jerk. So we're going to talk about what that means a little bit. First, you can't threaten with violence or criminal activity. I have seen a couple of situations where someone's threatened violence, but to Terry's point, more often than not, if the threats do arise, it's in the context of criminal activity. Even if it's not an overt threat saying, hey, I'm going to send the police over, they're going to arrest you, throw you in the back of the squad car and lock you up. There are implicit threats of criminal activity and saying, hey, look, I'm trying to help you out, debtor. I really need you to pay this. Otherwise, you're going to get arrested and get thrown in jail. Talk with your client, talk with the consumer in detail about the communications they've received. And trust me, there will be frequent communications from the debt collector. They call quite frequently. So try to find out the substance of those communications, those telephone calls, those voicemail messages, what's gone on, what the substance of those communications have been. In addition to a prohibition on threatening violence or criminal activity, debt collectors are prohibited from using obscene or profane language. Again, this is one that I've seen violated more often than not, is that there can be some abusive or profane language involved. One area where I've seen this, unfortunately, is the use of racial epithets. So take a look for that with respect to communications with your client. Debt collectors cannot publish lists of debtors or debts or advertise debts or blacklist individuals. So there's not really this email forward that's going around to all debt collectors, at least there shouldn't be, saying, hey, or creditors rather, saying, don't lend to this person, they're on the blacklist. So something we need to be aware of. Debt collectors cannot allow the phone to ring repeatedly for the purpose of harassing or aggravating individuals or just being annoying. I think that's sort of an interesting prohibition. Finally, and again, this gets into the gray a little bit, but debt collectors cannot place telephone calls to debtors without a meaningful disclosure of their identity. And sometimes there can be a question in terms of whether the disclosure has been meaningful in terms of describing who they are, purpose of the call, and why they're contacting the debtor. So again, all of that is just to encourage you to engage in a thorough conversation with the consumer to understand really what the substance of the conversations that have taken place between the debtor and the debt collector are, so that you can understand whether there has been any type of abusive or harassing behavior. Getting on to the next sort of large category of potential violations is false or deceptive acts. Here we've got a general prohibition against false, deceptive, or misleading statements. More specifically, the debt collector cannot represent themselves as an attorney, and that's actually one that I've seen surprisingly frequently. Not all the time, but surprisingly frequently. There have been individuals that have represented themselves as an attorney when they really are not. Again, cannot make any statement or implication that non-payment will result in arrest or criminal prosecution. And one thing that I found interesting is that you can't threaten a lawsuit or garnishment or seizure of property unless there's a legal ability to do so. And that gets to sort of Terry's point, which I think is interesting, is that while the statute of limitations is an affirmative defense, there is some case law that would indicate that while it might not be a bar under the state law claims that a debt collector may have, there may be some implication of the Fair Debt Collection Practices Act if the debt collector knows that really the claim is unenforceable and yet they're making legal threats in any event. So sort of interesting that there's that dichotomy there, where state law goes one way perhaps and federal law goes another. So be aware of that. Also, debt collectors cannot threaten or to report false credit information, and they also can't report false credit information that can lead them into some unenviable waters. Again, there's just a general prohibition against unfair or unconscionable acts. They can't, debt collectors cannot attempt to obtain or collect any amount that's not authorized by law. Electronic transfers are one area where this comes up quite a bit, where consumers will sometimes authorize a one-time payment or authorize a payment in a certain amount. And if that doesn't satisfy the entirety of the obligation, in some cases, I haven't seen it very often, Terry, I don't know if you've seen it very often, but I've seen it sometimes where the collector has gone ahead and initiated either an additional transaction or a transaction in excess of the amount that was explicitly authorized by the debtor. And so if that happens, debt collectors running afoul of the Fair Debt Collection Practices Act there, as well as what's it called, the Electronic Funds Transfer Act. I think there's another act there I know there's another act there. I think it's called the Electronic Funds Transfer Act. So be aware of that. Terry already hit upon this, but the debt collectors cannot solicit or accept post-dated checks without providing written notice of at least 3 days of the debt collector's intention to process and deposit that check. And again, as Terry pointed out, cannot solicit or accept a backdated check with the post-dated check for purposes of threatening criminal prosecution. So we have that state law and federal law go hand in hand on that. Again, as you can see, there are a host of ways that a debt collector can engage in unfair or abusive or harassing or deceptive acts to violate the FDCPA. So again, we'll go back to the same refrain. Make sure that you engage in a thorough analysis and conversation with the consumers to really try and understand the substance and content of all of the communications that have gone on, because there may be a violation of the Fair Debt Collection Practices Act with respect to the efforts of the debt collector to collect a debt. So let's go ahead and let's assume that one of these provisions has been violated, that we have a violation of the FDCPA. Let's talk about what to do if we discover a violation. First, we're going to talk about sort of the statutory remedies that are available and statutorily what to do. But then we're going to talk just maybe a little bit about practically what we might want to do. So first of all, we have the statute provides just very broadly a private right of action in the event of a violation of the Fair Debt Collection Practices Act. And again, since it's a federal claim, it can be filed in federal court. And if it's filed in state court, oftentimes in my experience, you will see those cases removed to federal court. But you'll notice that enforcement of the FDCPA is interesting because it's a strict liability statute. If there's a violation, there's a violation. And if there's a violation, then really there are three things that we want to talk about in terms of remedies if there's a violation. The first is, of course, actual damages, right? If someone has sustained actual damages by a violation of the Fair Debt Collection Practices Act, that individual, just like our tort law right, can collect actual damages. But oftentimes with the FDCPA, the question of actual damages is sort of gray, right? I mean, what are the actual damages of having your phone ring for an excessive amount of time to annoy you? Maybe, I don't know, negligible damages. But in any event, even if there are not any actual damages, in the case of an action under the FDCPA by an individual, there are statutorily provided damages in an amount not to exceed $1,000. So you can get $1,000 for violation of the Fair Debt Collection Practices Act. But probably, honestly, the biggie from a practical standpoint with respect to where the teeth are at in the FDCPA is that it statutorily provides for attorney's fees. So if a party prevails, they are entitled to attorney's fees. And I'll let you all on the slides read this if you'd like, but just in that last paragraph, take note that examples of attorney's fees in some cases have been $25,000 where the violation was where the debt collector used the phrase verifies validity of this debt, which goes back to a compliance issue, as well as around $10,000 for a similar violation. So really the teeth of the FDCPA are going to come into play with respect, more often than not, with respect to the attorney's fees provision. And that's an area where, as Terry sort of highlighted early on in her presentation, there can be some remuneration for attorneys being involved in this type of work. Even if it's not direct compensation from the client, there can be statutory fees that are available to you. So keep that in mind. That's where the damages are going to come into play, where the teeth are going to come into play. If you decide that there's a violation, you know what, you're going to pursue it out of the goodness of your heart, or if you're going to pursue it to try and collect these attorney's fees, or those two things are not mutually exclusive. Being a good person, you also want to collect the fees. You decide to take the case. I want to make you aware of some of the defenses that are available to Fair Debt Collection Practices Act claims. It's a wide range of defenses. We're going to talk a little bit about these defenses, just so you're aware of what you can expect and what you need to prepare for as you are taking a case that involves the Fair Debt Collection Practices Act. First, obviously, the defense could be invoked that there was just no violation, that whatever the alleged violation is, it never took place. There was never a phone that rang off the hook. There was never any abusive language that was utilized. Every document was in compliance with the FDCPA. Whatever it is, it just operates as a simple denial that there was no violation. The next, and we'll talk about this one in more detail here in a moment because it's sort of an interesting defense, is the bona fide error defense. And talking about how, hey, you know what, mea culpa, there was a violation of the FDCPA, but it was a bona fide error, so we're going to not be penalized this time around. We'll talk about what that means here in a moment. Of course, we've got a statute of limitations defense. And we've got a defense, which is another interesting defense, that there's bad faith or harassment on the part of the consumer. And what's interesting here is sort of like the Tennessee Consumer Protection Act, is if the FDCPA claim is brought in bad faith or for purposes of harassment and there are no grounds to bring the FDCPA claim, then in fact the defendant's attorney can be awarded attorney's fees if it's brought in bad faith. So don't bring a bad faith claim just in general, right? Because we're good lawyers, we're ethical lawyers, but be aware that it can cost you some money here with respect to the FDCPA. So let's talk in a little more detail about the bona fide error defense. All right, so here are the standards under that defense, and I'll just have you note there at the bottom that the burden of proof for each of these elements is on the debt collector, and the standard there is by a preponderance of the evidence. So what are the requirements? Well, violation was not intentional, it was in good faith, it resulted from a genuine error, that the debt collector employs reasonable procedures to prevent violations, and that there's a maintenance of procedures in place at the debt collector to check and avoid such errors. So what are we talking about? Well, we're talking about things like training, like legitimate training for debt collectors. We're talking about manuals, we're talking about quality control, we're talking about spot checks like listening in on telephone conversations, sometimes recording of calls, that type of situation. So that's what we're looking at with respect to that particular defense. From a practical standpoint, what I've seen, and especially as I was representing, sometimes as I was on the other side, representing defendants in FDCPA claims, in order to cap some of the attorney's fees that may be available, sometimes a strategy that's employed by debt collectors and their attorneys is to simply make an offer of judgment and say, hey, you know, early on in the case, and say, look, yeah, we violate the FDCPA. That way, we'll pay the $1,000 and some nominal attorney's fees, but there won't be the protracted litigation that could result in some of these awards of attorney's fees that we've seen in the neighborhood of $10,000 to $20,000. So sometimes we've seen that. Now, why is that important with respect to what we're talking about today, which is representing consumers? We're not talking about how to make money off the FDCPA today, although we've hinted at that. But we're talking about how to represent consumers, right? Well, what I have found is that in a lot of the situations that Terry has described earlier on, in a lot of the situations that we can all think of where a consumer is being sued for non-payment of a debt, is that there's a reason that they're being sued for non-payment of a debt. Well, the obvious reason is they haven't paid it. But behind the scenes is a lot of times if we're dealing with indigent folks, it's because they can't pay it. There's just no way to pay it. And if they can pay it, whatever money they pay for that, it's not going to go to things like health care or to their rent, as Terry pointed out, or to their food, as Terry pointed out. It's going to really put a big dent in their budget. So why do we want to look for violations of the FDCPA when we're representing a consumer in these situations? Well, frankly and practically, it can be used as just another tool in trying to resolve the matter, trying to settle the matter. Say, hey, look, you know what, my person may owe this debt, but your person also violated the Fair Debt Collection Practices Act. Maybe there's a way we can try to work this out so that we can just maybe part ways, and that your person doesn't have to pay the statutory damages, my attorney's fees, my person maybe doesn't need to pay the debt. Maybe there's an amicable resolution that we can reach. So again, that's, from a practical standpoint, it's a big reason to look for violations of the Fair Debt Collection Practices Act, is it can aid you in the overall representation of the alleged consumer debtor in any of these claims, if there is a violation of the DCPA. Even if it's in General Sessions Court, right, and you haven't filed a counterclaim for violation of FDCPA, you say, hey, look, we're in Sessions Court over here in whatever county you're in. Don't make me go down to the federal courthouse and file this FDCPA claim. Don't make me raise that here, and then we'll, have it taken up to circuit court and then maybe remove it to federal court. Nobody wants to deal with that. Let's just try and get things resolved. So be cognizant of how the FDCPA can practically help you to represent your consumer debtor client and get things resolved. I've seen that work a number of times, actually, when there's been a violation on that. So we've gone through today sort of the background of the Fair Debt Collection Practices Act. We've gone through some of the compliance requirements on the front end in terms of the communications between a debt collector and the debtor. We've talked about violations, and we've talked about some of the enforcement mechanisms. Now I want to talk just for a moment some of the ethical considerations under the FDCPA. And the first is fee structures. Again, if you're representing someone who's of modest means, an indigent client, probably can't pay you any money, so just be mindful of how you structure any type of agreement for representation in terms of where any recovered attorney's fees, how that'll be worked out, what your compensation will look like. Watch out for unrepresented parties, especially on the side of the debt collector side. If you haven't gone to court yet and you're engaging in communications with the debt collector, watch out for giving legal advice, or watch out for any attorneys that may be representing the debt collectors, or if the debt collectors are attorneys themselves, just watch out for dealing with unrepresented parties, much the same like we would in any case, right? Unauthorized practice of law. This is an interesting one because I think that UPL comes into play with respect to the FDCPA based upon what I've seen and what I've read, is that sometimes you can run into UPL issues when the debt collector, non-attorney debt collector, is providing legal advice to your client or to the consumer debtor. Maybe they're on the phone and they're not being abusive or harassing, but they start to provide legal advice. Hey, here's what you need to do. Here's what you should do. So really the UPL issue comes into play obviously on the other side. So just be aware that maybe there's some UPL issues on the debt collector side, which again just gives you another arrow in your quiver in terms of trying to resolve matters. And harassment. Really this, again, probably goes for those of you who, if you are watching this, that are debt collectors. Obviously, as attorneys, we're living by the model rules. We're not going to engage in harassing behavior. But also watch out for that, because not only is it violative of the rules of professional conduct, but it can subject you to liability under the FDCPA. So finally, let's just talk real quick. Let's recap some summary and best practices. Evaluation of the FDCPA looks the same really for both sides of the coin. So what you really need to do is engage in a detailed conversation starting at the very beginning. What's the initial written communication look like? What did it contain? What did the subsequent written communications look like? What was the content of any and all telephone calls that took place between the debt collector and the debtor? Once you have sort of established that and you're thinking, hey, there may be a violation here, really, get involved in digging into the statute and making sure that the parties are covered entities under the FDCPA, especially debt collectors. Again, if it's a creditor, FDCPA is not going to apply. There may be other remedies, but it's not going to be the Fair Debt Collection Practices Act. We're looking for debt collectors whose primary business is engaging in the collection of debts on behalf of third parties. We want to look at damages. Are there actual damages available? Are we talking about statutory damages? Are we talking about attorney's fees? We want to make sure that there are records. Are there any recorded telephone calls? How many of these letters did your client save? Is there a way to get copies of them from the debt collector? You want to preserve all of the evidence that you can. Oftentimes what I've seen in my experience is that the FDCPA issues come up in, of course, the debt collection cases that Terry was talking about. They also come up a lot in mortgage cases and in credit reporting cases. The Fair Debt Collection Practices Act crops up in a lot of areas of the law. So it's not just strictly limited to someone getting sued for non-payment of medical bills or someone getting sued for non-payment of a credit card. It really can come into play when you're dealing with mortgage issues, foreclosure cases, credit reporting cases, a panoply of cases that touch upon a client's finances. There can be FDCPA issues that crop up. So we would encourage you to look out for those, because they will aid you as you represent these indigent or clients or individuals of modest means, because it will give you, again, that leverage to try and resolve the case in an amicable manner, and try to avoid having to go to federal court and that type of thing. So I think I spoke quickly, but I think I hit those points. And Terry, you got any comments or observations about the FDCPA?
Well, just as I said, we see these kind of violations constantly. And I think there's money to be made by lawyers who want to specialize in that. Excuse me.
Well, excellent. Well, thank you very much, and thank you all for participating, and thank you all for watching, and I hope to see you out there. Thanks a lot. Have a good day.